Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Wilkinson v. Garland. In this case, the court considered this issue is an agency determination that a given set of established facts does not rise to the statutory standard of exceptional and extremely unusual hardship, a mixed question of law and fact reviewable under 8 U.S.C. Section 1252a, 2d, or instead a discretionary judgment call unreviewable under Section 1252a, 2bi? The case was decided on March 19, 2024. The Supreme Court held that an immigration judge's discretionary decision that a given set of established facts does not satisfy 8 U.S.C. Section 1229 BB1D's exceptional and extremely unusual hardship standard for determining eligibility for cancellation of removal is a mixed question of law and fact, reviewable under Section 1252a, 2D's jurisdiction restoring exception for questions of law. Justice Sonia Sotomayor authored the majority opinion of the court. The application of the statutory hardship standard to an established set of facts presents a quintessential mixed question of law and fact. While this determination requires close examination of the facts, under the court's precedent in Guerrero-Lasprilla v. Barr, a mixed question that requires factual analysis is still a mixed question, and therefore a question of law that courts have jurisdiction to review. The court rejected the government's arguments that Guerrero-Lasprilla should be limited to judicially created standards, that the statutory history precludes review, and that a primarily factual mixed question is a question of fact. Nothing in Section 1252a, 2d, suggests questions of law is limited to only certain types of mixed questions. While courts still cannot review the underlying factual determinations, the application of the hardship standard to those facts is reviewable as a mixed question of law and fact, albeit under a deferential standard of review given the factual nature of the inquiry. The Third Circuit's holding that it lacked jurisdiction to review hardship determinations was therefore erroneous. Justice Ketanji Brown Jackson authored an opinion concurring in the judgment, expressing skepticism that Congress intended the phrase questions of law in Section 1252a, 2d, to encompass all mixed questions of law and fact, as the majority concluded. However, she agreed with the majority's judgment based on the controlling precedent of Guerrero-Lasprilla. Chief Justice John Roberts authored a dissenting opinion in which he agreed with Justice Samuel Alito's dissent that while Guerrero-Lasprilla was correctly decided, the majority erred in this case by reading the language in that case too broadly. Justice Alito, joined by Chief Justice Roberts and Justice Clarence Thomas, dissented, arguing that the court's broad reading of questions of law in Guerrero-Lasprilla defies common sense and would result in the exception nearly swallowing the rule, which Congress could not have intended when it enacted Section 1252a, 2b, and Section 1252a, 2d. He contended that the hardship determination is overwhelmingly a factual question that should not be classified as a reviewable question of law. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. To be eligible for cancellation of removal and adjustment to lawful permanent resident status, a non-citizen must meet 4 statutory criteria. The last requires a showing that the non-citizen's removal would result in exceptional and extremely unusual hardship to a U.S. citizen or permanent resident family member. Petitioner Situ Kamu Wilkinson argues that his removal would cause exceptional and extremely unusual hardship to his U.S. citizen son, who suffers from a serious medical condition and relies on Wilkinson for emotional and financial support. An immigration judge, IJ, held that this hardship did not rise to the level required by statute, and the Board of Immigration Appeals, BIA, affirmed. The Third Circuit dismissed Wilkinson's petition for review, holding that it lacked jurisdiction to review the IJ's hardship determination. The question in this case is whether the IJ's hardship determination is reviewable under the section, which gives courts of appeals jurisdiction to review questions of law. This court holds that it is. The application of a statutory legal standard, like the exceptional and extremely unusual hardship standard, to an established set of facts is a quintessential mixed question of law and fact. Accordingly, this court reverses. When an IJ finds a non-citizen removable for violating the immigration laws, Congress provides several avenues for discretionary relief. Relevant here, an IJ may cancel removal of a non-citizen who meets certain statutory criteria. Cancellation of removal permits a non-citizen to remain in the country lawfully. An IJ deciding a non-citizen's request for cancellation of removal proceeds in 2 steps. First, the IJ must decide whether the non-citizen is eligible for cancellation under the relevant statutory criteria. Second, an IJ decides whether to exercise his discretion favorably and grant the non-citizen relief in the particular case. A non-citizen bears the burden of proving that he both satisfies the applicable eligibility requirements and merits a favorable exercise of discretion. Congress enumerated certain statutory criteria to govern the first step of an IJ's cancellation of removal determination. For a non-citizen who never received lawful permanent residence, i.e., a green card, those criteria are stringent. He is eligible for cancellation of removal only if he meets 4 requirements. 1. He has been physically present in the United States for a continuous period of not less than 10 years before he applies. 2. He has been a person of good moral character during such period. 3. He has not been convicted of certain criminal offenses. And 4. He establishes that removal would result in exceptional and extremely unusual hardship to his spouse, parent or child, who is a U.S. citizen or lawful permanent resident. After determining whether a non-citizen meets these criteria, an IJ proceeds to Step 2 and decides whether to exercise discretion to cancel the order of removal in a particular case. Wilkinson was born in Trinidad and Tobago. After police officers beat, robbed, and threatened to kill him in 2003, Wilkinson fled to the United States on a tourist visa. He has remained in this country ever since, beyond the expiration of his visa. In 2013, Wilkinson had a son, M, with his girlfriend Kenyatta Watson. Both M and Watson are U.S. citizens. Wilkinson lived in Pennsylvania and worked to support M and Watson. M lived with Wilkinson and Watson for the first 2 years of his life. Then, because Wilkinson could not take care of his son and work at the same time, he and Watson decided M would have a better quality of life in New Jersey with his mother and her mother. Wilkinson took the train to visit his son every weekend and provided almost half his monthly wages, $1,200 per month, in informal child support. M suffers from severe asthma, which requires hospital treatment multiple times a year. Wilkinson helped M with his inhaler and medications and knew his regimen well. Watson suffers from depression and does not work, so she also relies on Wilkinson's financial and childcare support. Wilkinson worked as a handyman and a laborer in construction. In 2019, police found drugs in a house where he had been hired to work on repairs. Despite Wilkinson's protests that neither the house nor the drugs were his, the police arrested him. When Wilkinson appeared in a Pennsylvania courthouse to contest the charges, he was arrested and detained by federal immigration officers. The criminal charges were ultimately withdrawn. M was 7 years old when Immigration and Customs Enforcement detained his father. Afterwards, M began to exhibit behavioral issues. M became sad, acted out, and broke things. M's teacher texted Watson every day saying that M was no longer focused and needed to talk to a counselor. Wilkinson called his son every other day from immigration detention. When M hung up the phone, he cried and said he wanted his father to come home. Wilkinson conceded before the IJ that he was removable for overstaying his tourist visa. He asked for relief from that removal, claiming eligibility for asylum, withholding of removal, and protection under the Convention Against Torture. Relevant here, he also applied for cancellation of removal based on hardship to his U.S. citizen son. M. The U.S. Department of Homeland Security, DHS, stipulated that Wilkinson met the first 3 statutory criteria for eligibility, namely, continuous physical presence, good moral character, and lack of specific criminal bars, but contested the last, exceptional and extremely unusual hardship to M. Wilkinson, Watson, and M's grandmother, all testified in support of Wilkinson's applications for relief. In evaluating Wilkinson's applications, the IJ found Wilkinson credible, and credited the testimonies of each witness in full. The IJ then turned to cancellation of removal, and recited the standard for exceptional and extremely unusual hardship adopted by the BIA. To meet this standard, a non-citizen must demonstrate that a qualifying relative would suffer hardship that is substantially different from or beyond that which would ordinarily be expected to result from their removal, but need not show that such hardship would be unconscionable. In evaluating whether a non-citizen meets this standard, IJS must consider a range of factors, including the age and health of the qualifying family member. All hardship factors should be considered in the aggregate to determine whether the qualifying relative will suffer hardship that rises to the level of exceptional and extremely unusual. The IJ then applied this standard to the established facts. He found that M's asthma was a serious medical condition, and that Wilkinson provided emotional and financial care to his son. He found that M had been struggling since Wilkinson's detention. Nevertheless, the IJ held that M did not meet the statutory standard for exceptional and extremely unusual hardship. The IJ reasoned that M received medical insurance from the government, and that he and his family might qualify for other public assistance if necessary. Although Wilkinson provided emotional support, the IJ noted that M had lived without Wilkinson's daily presence for most of M's life. The IJ recognized that M and his mother would suffer some financial hardship from Wilkinson's removal. Yet the IJ reasoned that Wilkinson had not provided evidence that he would be unable to work and support his family from Trinidad and Tobago. The IJ also noted that M's mother was able to work even though she had primarily been caring for M. He reasoned that M's grandmother, who had helped care for M before, could continue to do so. Based on the aggregate of the factors that he weighed, the IJ found that any financial or emotional hardship was not beyond that which would normally be expected from the removal of a parent and provider. Ultimately, the IJ held that the evidence of hardship in the case did not rise to the level of exceptional and extremely unusual hardship. Because he held that Wilkinson was statutorily ineligible for cancellation of removal, the IJ did not reach determining whether or not to exercise his discretion to grant the application for cancellation of removal. The IJ denied Wilkinson's application. Wilkinson appealed the IJ's decision to the BIA. The BIA affirmed without issuing an opinion. Wilkinson petitioned the Third Circuit for review, arguing that the court had jurisdiction to review the BIA's hardship determination as a mixed question of law and fact. The Third Circuit held that because the hardship determination was discretionary, it lacked jurisdiction to review it. It therefore dismissed that part of Wilkinson's petition. Wilkinson asked this court to grant certiorari to resolve whether the IJ's determination that a given set of established facts does not rise to the statutory standard of exceptional and extremely unusual hardship is a mixed question of law and fact reviewable under Section 1252A, 2D, or whether this determination is a discretionary judgment call unreviewable under Section 1252A, 2BI. This court granted certiorari. The courts of appeals are split on this question. This court now holds that the application of the exceptional and extremely unusual hardship standard to a given set of facts is reviewable as a question of law under Section 1252A, 2D. Section 1252A, 2D, provides that a court of appeals may consider final orders of removal via petitions raising constitutional claims or questions of law. In Querrero-Lasprilla, this court held that the statutory phrase questions of law includes the application of a legal standard to undisputed or established facts, also referred to as mixed questions of law and fact. The statutory criterion of exceptional and extremely unusual hardship is a legal standard that an IJ must at the first step apply to a set of established facts. This court therefore holds that it is a question of law over which Section 1252A, 2D provides judicial review. The hardship determination in this case was not discretionary, because the IJ held that M's hardship did not satisfy the statutory eligibility criteria. He never reached the second step and exercised his unreviewable discretion to cancel or decline to cancel Wilkinson's removal. The Third Circuit therefore erred in holding that it lacked jurisdiction to review the IJ's determination in this case. Section 1252 generally grants federal courts the power to review final orders of removal. It then strips courts of jurisdiction for certain categories of removal order. Finally, it restores jurisdiction to review constitutional claims or questions of law. Relevant here? Section 1252A, 2BI, strips courts of jurisdiction over judgments regarding the granting of discretionary relief under Section 1229B. Section 1229B governs cancellation of removal. Section 1252A, 2BI, therefore strips courts of jurisdiction over a judgment on cancellation of removal. The Third Circuit held that it had no jurisdiction over the part of Wilkinson's petition related to the hardship determination on this basis. That holding ignores Section 1252A, 2D, which restores jurisdiction to review questions of law. Two clear rules govern the interaction between Section 1252A, 2BI, which strips jurisdiction over judgments regarding discretionary relief, and Section 1252A, 2D, which restores it for legal questions, laid out in two of this court's previous cases, Guerrero-Lasprilla and Patel. Guerrero-Lasprilla held that petitions raising mixed questions of law and fact are always reviewable as questions of law under Section 1252A, 2D. Patel held that questions of fact underlying denials of discretionary relief are unreviewable under both Section 1252A, 2BI, and Section 1252A, 2D. Those two rules resolve this case. In Guerrero-Lasprilla, Section 1252A, 2C, stripped courts of jurisdiction over two non-citizens' orders of removal via a different provision targeting certain criminal convictions. Those non-citizens had sought to reopen their immigration cases after being removed, because a change in the law regarding their criminal convictions rendered them newly eligible for discretionary relief. Although the 90-day time limit to reopen their cases had expired, they argued that the limit should be equitably tolled. The BIA denied their request, concluding that each had failed to demonstrate the requisite due diligence. When the non-citizens petitioned the Fifth Circuit for review of that decision, the court held that it lacked jurisdiction to decide the question. The Fifth Circuit reasoned that whether a non-citizen acted diligently in attempting to reopen removal proceedings for purposes of equitable tolling was a question of fact, not a question of law that would restore jurisdiction under the statute. This court reversed. The court held that questions of law in the statute included mixed questions of law and fact. The application of a legal standard to undisputed or established facts is a mixed question. Whether the BIA had correctly applied the equitable tolling due diligence standard to the facts was therefore a question of law reviewable by a court of appeals. In doing so, this court rejected the government's primary argument that questions of law referred only to mixed questions that are primarily legal rather than primarily factual. Such an interpretation, the court reasoned, would forbid review of any BIA decision applying a properly stated legal standard, irrespective of how mistaken that application might be. This court also rejected the government's alternative argument that questions of law should be limited to pure questions of law based on the statutory context, history, and relevant precedent. Finally, the court rejected the government's argument that interpreting questions of law to cover all mixed questions would undercut Congress' efforts to severely limit and streamline judicial review. The statute had no effect on the unreviewability of factual determinations which, as the court noted, are an important category in the removal context. The issue of questions of fact came before this court in Patel. There, the non-citizen checked a box in his application for a state driver's license indicating that he was a U.S. citizen when he was not. Because of that misrepresentation, he became statutorily inadmissible to adjust his status to permanent resident. Later, in removal proceedings, the non-citizen conceded he was removable, but argued that he mistakenly checked the box and lacked the statutory mens rea. The IJ found him not credible, based partly on the fact that he had a strong incentive to deceive state officials about his citizenship status to obtain a state driver's license. The non-citizen appealed, arguing that the basis for the credibility determination was clearly wrong. Under state law, he was entitled to a driver's license without being a citizen. The BIA determined that the IJ's factual findings were not clearly erroneous and dismissed the appeal. The 11th Circuit dismissed the petition for review, holding that it lacked jurisdiction under the statute, which strips courts of jurisdiction to review any judgment regarding the granting of relief under the adjustment of status provision. The court concluded that both whether the petitioner had testified credibly and whether he had subjectively intended to misrepresent himself as a citizen were factual determinations that fell within the statute's jurisdictional bar. This court affirmed. The court held that these factual findings, which formed the basis for the denial of relief, fell within the statute's jurisdiction stripping provision. Further, the statute did not restore jurisdiction, because questions of fact are indisputably not questions of law. Relying on previous precedent, the court noted that questions of fact were the major remaining category for which Congress could still strip courts of jurisdiction. Wilkinson does not dispute that the statute generally strips courts of jurisdiction to review cancellation of removal decisions. He argues, instead, that the statute restores jurisdiction in this case because the threshold question whether a non-citizen is statutorily eligible for cancellation of removal requires a court to assess whether an IJ correctly applied the statutory standard to a given set of facts. This court agrees that the application of the statutory exceptional and extremely unusual hardship standard to a given set of facts presents a mixed question of law and fact. Previous precedent compels this conclusion. That precedent held that the statutory term questions of law in the statute includes the application of a legal standard to established facts. That term included the application of the due diligence standard for equitable tolling to a given set of facts. Similarly, the exceptional and extremely unusual hardship standard in the statute is a legal standard that an IJ applies to facts. The standard may require an IJ to closely examine and weigh a set of established facts, but it is not a factual inquiry. It is, inescapably, a mixed question of law and fact. Mixed questions are not all alike. A mixed question may require primarily legal or factual work. It may require courts to expound on the law by amplifying or elaborating on a broad legal standard. Or it may immerse courts in case-specific factual issues, compelling them to marshal and weigh evidence. That a mixed question requires a court to immerse itself in facts does not transform the question into one of fact. It simply suggests a more deferential standard of review. As interpreted by the BIA, the application of the exceptional and extremely unusual hardship standard requires an IJ to evaluate a number of factors in determining whether any hardship to a U.S. citizen or permanent resident family member is substantially different from, or beyond, that which would normally be expected from the deportation of a close family member. That application conceitedly requires a close examination of the facts. Yet that was also true of the due diligence standard, which required a court to evaluate whether a non-citizen was adequately conscientious in his pursuit of a filing deadline. A mixed question that requires close engagement with the facts is still a mixed question, and it is therefore a question of law that is reviewable under the statute. Under Patel, of course, a court is still without jurisdiction to review a factual question raised in an application for discretionary relief. As in Patel, that would include the IG's underlying factual determination that Wilkinson was credible, or the finding that M had a serious medical condition. When an IJ weighs those found facts and applies the exceptional and extremely unusual hardship standard, however, the result is a mixed question of law and fact that is reviewable under the statute. The government's counterarguments largely seek to relitigate the previous precedent. This court is unpersuaded. First, the government argues that the statutory standard is not a legal standard at all. It asks this court to limit the previous case solely to judicially created standards like the due diligence standard for equitable tolling. Nothing in that case or this court's other precedents supports such a distinction. This court has frequently observed that the application of a statutory standard presents a mixed question of law and fact. That case itself reflected this understanding. This court sees no reason to treat the statutory hardship standard here any differently from a judicially created due diligence standard. Second, the government argues that a 1928 case and the statutory history of the hardship requirement preclude review. In that case, the court evaluated a wartime tax relief provision that was in effect from 1919 to 1921. That provision allowed the Internal Revenue Service Commissioner to use a special method for determining a company's tax burden, if computation under the regular scheme would work an exceptional hardship. The statute granted the Commissioner power to act, for the most part, without any justification. The Commissioner did not have to make findings of fact, and had to create a meager record only if he ordered a special assessment. This court therefore concluded that the IRS's exceptional hardship determination was a question of administrative discretion not subject to judicial review. That case has no relevance to the question presented here. The government provides no basis for why this court should port the interpretation of exceptional hardship from a 1919 tax relief provision to a 1996 immigration relief provision. An IJ applying the exceptional and extremely unusual hardship standard must create an extensive record of his decision-making, including detailed fact-finding and the application of BIA precedent. Additionally, that case did not evaluate the term exceptional hardship against the background of a jurisdiction restoring provision, like the one enacted in 2005. The government's argument from the statutory history of the hardship requirement is no more persuasive. The precursor to cancellation of removal was suspension of deportation. That relief was available only to a person whose deportation would, in the opinion of the Attorney General, result in exceptional and extremely unusual hardship to the non-citizen himself or a qualifying relative. The government argues that this court should read that discretion back into the current version of the statute. The government's request to reinstate statutory language removed by Congress is particularly unavailing, because Congress chose to retain similar language in provisions governing other forms of discretionary relief subject to the statute's bar on judicial review. Congress could have, but did not, do the same with the hardship requirement in the statute. The government's final argument is one this court already rejected in the previous case, that a primarily factual mixed question is a question of fact. Such a rule would require a court of appeals evaluating its jurisdiction to determine in every instance whether a particular legal standard presented a primarily factual or primarily legal inquiry. Nothing in the statute or its statutory context suggests that questions of law is so limited. This court declined to require the courts of appeals to engage in that complex line-drawing exercise, and it declines to do so here. Today's decision announces nothing more remarkable than the fact that this court meant what it said in Guerrero-Lasprilla: mixed questions of law and fact, even when they are primarily factual, fall within the statutory definition of questions of law in Section 1252A, 2D, and are therefore reviewable. That holding does not render Section 1252A, 2's jurisdiction stripping provisions meaningless. As this court said in Guerrero-Lasprilla and reiterated in Patel, those provisions still operate to exclude agency fact-finding from review. The facts underlying any determination on cancellation of removal therefore remain unreviewable. For instance, an IJ's fact-finding on credibility, the seriousness of a family member's medical condition, or the level of financial support a non-citizen currently provides remain unreviewable. Only the question whether those established facts satisfy the statutory eligibility standard is subject to judicial review. Because this mixed question is primarily factual, that review is deferential. For these reasons, the court reverses the Third Circuit's jurisdictional decision, vacates its judgment, and remands the case for further proceedings consistent with this opinion. It is so ordered. Justice Jackson, concurring in the judgment. The Immigration and Nationality Act plainly constrains judicial review of discretionary relief determinations. It first strips courts of jurisdiction to review any judgment regarding the granting of relief under provisions including 8 U.S.C. Section 1229b, which governs cancellation of removal. Then, the Act restores judicial review for only a subset of claims, constitutional claims or questions of law raised in a petition for review in the courts of appeals. Through these provisions, Congress made clear that courts should play a minimal role in the discretionary relief process. In Guerrero-La Esprilla v. Barr, the court interpreted the phrase questions of law in Section 1252a, 2d, to include mixed questions of law and fact, i.e., the application of a legal standard to undisputed or established facts. Today, the court removes any doubt that the phrase questions of law encompasses all mixed questions, even those that are primarily factual. Thus, an immigration judge's determination that a non-citizen's removal would result in exceptional and extremely unusual hardship presents a judicially reviewable mixed question. Pointing to our precedent, the court holds that Guerrero-La Esprilla compels this conclusion. I am skeptical that Congress intended questions of law as used in Section 1252a, 2d to sweep so broadly, given the statutory scheme. The legislative history of the provision, though not conclusive, provides additional evidence to the contrary. As the dissent observes, under a maximalist reading of questions of law, the exception to limited judicial review is poised to swallow the rule. If that reading is correct, Congress went through an awful lot to achieve relatively little. I had not yet joined the court when it decided Guerrero-La Esprilla, but I agree that Guerrero-La Esprilla controls this case. The fundamental principle of stare decisis, that today's court should stand by yesterday's decisions, has enhanced force when a decision interprets a statute. Congress remains free to revise the statute, and it should do so if we have strayed from its intent concerning the scope of judicial review set forth in Section 1252a, 2d. I concur in today's judgment, with the understanding that the jurisdiction stripping provision is not meaningless. When reviewing denials of discretionary relief, courts should respect the choice of Congress, reflecting the will of the people, to limit judicial interference. Courts cannot review the facts underlying a hardship determination in the cancellation of removal context, and they should carefully distinguish between application of the exceptional and extremely unusual hardship legal standard, such as it is, and those unreviewable facts. Chief Justice Roberts, dissenting. I join the opinion of the court in Guerrero-La Esprilla v. Barr and continue to believe that it was correctly decided. I agree with Justice Alito's dissent in this case, however, that the court errs in reading the language in Guerrero-La Esprilla as broadly as possible, indeed to the outer limits of its possible reach. Nothing in Guerrero-La Esprilla requires such a reading, and I accordingly join Justice Alito's dissent. Justice Alito, with whom the Chief Justice and Justice Thomas join, dissenting. In the 1996 Illegal Immigration Reform and Immigrant Responsibility Act, FIRA, Congress sought to control illegal immigration and streamline the procedures for removing illegal aliens who had been convicted of criminal offenses. A key provision of the act is 8 U.S.C. Section 1252a, 2bi, which provides that no court shall have jurisdiction to review any judgment regarding the granting of certain forms of discretionary relief. After FIRA's enactment, this court flagged a substantial constitutional question that would arise if federal habeas courts were stripped of jurisdiction to review pure questions of law. Congress responded by enacting an amendment clarifying that Section 1252a, 2b, did not preclude review of constitutional claims or questions of law. In Guerrero-La Esprilla v. Barr, this court addressed the meaning of this amendment. The case concerned two criminal aliens who were ordered removed and then failed to ask to have their removal proceedings reopened by the 90-day statutory deadline. They argued, however, that the deadline should be equitably tolled. The Board of Immigration Appeals, BIA, rejected that argument, and the issue before us was whether the Court of Appeals had jurisdiction to review such a decision under Section 1252a, 2b and Section 1252a, 2d. The answer to that question depended on whether the correctness of the BIA's decisions was a question of law within the meaning of Section 1252a, 2d. The aliens urged us to decide the case on narrow grounds. They did not dispute the relevant facts, but argued that the BIA had applied the wrong legal test in holding that they had not acted with sufficient diligence to justify equitable tolling. Specifically, that the BIA had demanded a demonstration of maximum feasible diligence rather than reasonable diligence, which they claimed was the right test. The court ruled for the aliens, and in doing so stated broadly that questions of law include all questions that involve the application of the law to a particular set of facts. Under this statement, the phrase questions of law has a stunning sweep. It encompasses all sorts of discretionary rulings that depend almost entirely on the relevant facts, as a few examples of mundane trial court rulings illustrate. For one, take a trial court's denial of a request for a continuance or a decision about the length of a trial day or the days of the week during which a jury is required to sit. Such decisions are governed by a legal standard, albeit a very permissive one. the decisions cannot be unreasoning and arbitrary. But in the rare case in which such a decision is reversed on appeal, the appellate court is unlikely to say that the trial court made an error of law because it mistakenly thought a continuance would be unreasonable and arbitrary. Instead, the question on appeal would almost certainly be based on an assessment of the facts. Here is another example. Under the broad language of quaerere lasprilla, juries decide questions of law whenever they return a verdict in a criminal or civil case. If, for example, a jury in a criminal case finds that a defendant violated a statute that requires knowing conduct, the jury decides a question of law because it applies the law, as set out in the court's instructions on the meaning of knowing conduct, to the facts as they see them. Likewise, in a routine negligence case, the jury applies the law, as explained in the court's instructions on the meaning of negligence, to the facts shown at trial. When Congress responded to St. Cyr by enacting Section 1252A, 2d, did it mean to adopt this maximalist understanding of questions of law? St. Cyr never suggested that Congress was obligated to go that far, and if Congress had wanted to achieve the end that results from the court's broad statements in quaerere lasprilla, Congress might as well have repealed Section 1252A, 2b outright. Under the quaerere lasprilla formulation, the net effect of Section 1252A, 2b, and Section 1252A, 2d, is as follows. Before the enactment of those provisions, pure findings of fact were subject to review, but under a very deferential standard, namely, they could be overturned only if any reasonable adjudicator would be compelled to conclude to the contrary. Afterwards, pure findings of fact were not reviewable at all. Is it plausible that this pipsqueak of a change was Congress's cure for what it saw as undue delay in the conclusion of removal proceedings for criminal aliens? I hardly think so. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.